What's up, everybody? You are watching the Barbites podcast, the podcast for law students looking to life hack their legal careers and learn from the best and brightest in the field to find out how they got to where they are today. I'm your host, Michael Goldfaden, founder of the plaintiff's personal injury firm, Goldfaden Law, located here in San Diego, California. My guest today is Matthew Clendenin of the Clendenin Personal Injury Law Firm. Matt is somewhat of a local hero to us plaintiffs' personal injury attorneys here in San Diego because he's known for taking some really tough cases to trial. And in a time where COVID has shut down courthouses to civil trials for the past year, Matt has actually managed to render 2 verdicts, and he's got a 3rd case coming up just next week. Matt is here to talk to us not only about his wins, but also about some losses and what you can learn as a lawyer in defeat. Matt has been selected as a top 40 under 40 attorney by the National Trial Lawyers. He's also been selected as a rising star attorney by Super Lawyers, which is awarded to just 2.5% of lawyers in a given year. I'd like to give a warm Barbites welcome to Matthew Clendenin. Matt, thanks so much for being here today.
Thanks. This is going to be good. I'm looking forward to it.
Matt, I like to start the show by just giving you a little idea of what we're doing with Barbites. So Barbites is intended for law students, and we really want to give them an idea of, what does the finish line look like? If I want my career to turn out the way Matt's career has turned out, and I know you're just in the beginning of your young career at this point, but we'd like to show them the path and teach them the right steps to take along the way in order to get there. And so I think a reason that a lot of our students are tuning in today is to, number one, hear about your trial skills. Obviously, you are a lawyer who loves going to trial. You take on some really tough cases, as I just mentioned. And, I've heard from a trial attorney once that if you're not losing a trial every once in a while, you're probably not trying enough cases. So what is it about your personality that makes you want to rise to the challenge and take on these insurance companies for some of these really tougher cases?
Yeah, I hope I'm not across the finish line. I just hit, or I'm coming up on 10 years of practice. So I'm feel like I just left the starting line. But yeah, I love trial work. And what I love about it is you're representing an individual. When I was in law school, I actually interned at the public defender's office. Swore I was going to be a PD. And I liked the David versus Goliath aspect of representing an individual versus the government. In personal injury, you're representing an individual versus a multi-billion-dollar insurance company. And so I like the kind of the justice aspect of it. And the trial specifically, I just think that's a lot of people go to law school, when you're thinking about your students, seeing these movies, right? Like Tom Cruise in A Few Good Men. And my favorite civil legal movie is A Civil Action with John Travolta. Love it. But the reality is most legal jobs are outside the courtroom. Even what I do. You also are a trial lawyer.
Sure.
95% of what we do is outside the courtroom. And so I fight as hard as I can to get into the courtroom. And because that's what I love. That's game time. And if you're not getting in the courtroom as a trial lawyer, you're not doing what trial lawyers do. You're not a trial lawyer.
Yeah, and you mentioned, a couple of movies and a civil action. Obviously, that great book. I remember we had to read that book as a requirement before I actually went into law school. And I think a lot of law students have this romanticized idea of the legal profession for the exact reasons that you're talking about, right? We see trials on TV, we see them in movies all the time. Yet when you actually go and you start to practice, you realize 95% of the time, you're doing work behind the scenes and you don't actually get to go into trial. So, is there something in particular that allows you that part of your personality where you like to be in front of people and to do that? I mean, where does that come from for you?
Yeah, I'm an extrovert. I remember when I got married, my wife and I did some premarital counseling, and one of the things was the Myers-Briggs personality test.
Yeah.
And so, it's the ESTJ, like there's the
Yeah,
four quadrants, and I was the maximum extrovert. So I like interacting with people. In trials, you're interacting with the jury. You're sharing your client's story with the jury. You're putting on evidence, and then of course at the end of the trial, you get to give your closing argument. Which I love the science and all the different approaches to how do you best present your case? How do you influence a jury? And so I find that so interesting and challenging. And so, but me personally, I really do think it's you can't have a fear of public speaking if you're going to get up in front of 12 strangers and tell your client's story to them.
Yeah, and I had mentioned in the beginning that I want to talk to you about obviously the successes that you have been able to achieve in your young career. Before the podcast began today, you've sent me some huge results on cases that you have settled, verdicts that you have had. I know there was one case in particular that you've recently tried, and it resulted in a defense verdict. Okay, but in the same breath that I say this was a defense verdict, it's so important that you go to trial on these cases where insurance companies are undervaluing your client's case. And really just the fact that you're able to show an insurance company that you're stepping into the courtroom when they are not willing to give you full value for your client's injuries, that's a win for a plaintiff's attorney everywhere. So can you talk to us a little bit about this case in particular?
Sure. So this case in particular is it's the AMC case. I call it the AMC case. I represented Miss Tony Chase. She was a 70-year-old lady who slipped and fell at an AMC.
Great name, by the way.
It's
like sounds like a mock trial problem.
I know, right?
Court problem.
Yeah, Miss Chase went to AMC, and the facts. I mean, she went to AMC on Valentine's Day.
Oh, there.
With her two granddaughters.
Are you sure this isn't a mock trial?
No, I know. It's like you can't. Well, that's why I like trial, because you can't make it up. It's like Miss Tony Chase went to AMC in Mission Valley on Valentine's Day with her granddaughters. It had been raining out all day long. She went and saw her movie. She walked outside, and maybe many of your local students have been to the Mission Valley AMC.
I've been there.
I've been there many times. And it's super old. It was built in the 70s. Hasn't been changed since. And it has this smooth concrete outdoor gallery with steps. So Miss Chase walked down the steps and was on a flat part, and she just slipped. And then went down and broke her hip really badly. And she's not going to walk the same the rest of her life. And, but how do you pitch that story? Like, I can tell you how AMC pitched that story. Old lady slipped in the rain.
Right.
You're like, what are you going to do? The rain is wet. Guess what? It's slippery when it's wet. It's a tough case. But then we started digging, partly because this client I loved her. And, turns out AMC hadn't changed, altered, even cleaned the concrete for 30 years. And I think the thing that drew me to it was the pictures of the concrete, not just the pictures. I went out, and by the way, you got to go to the scene. You probably know this. Every case, you have to go to the scene and just be there. And when I went there, I picked another rainy day to go, and just the concrete looked scummy. And that to me was like, how much money is this business making? And you got scummy, smooth old concrete floors. So we dug into it. Turns out people fall every year and get hurt there.
Wow.
And they haven't done anything about it for years and years. They had this. I subpoenaed the public ambulance records. An ambulance goes there specifically for someone who slipped outside in the rain during the winter months, almost once a month. That someone goes out in an ambulance.
Wow.
And then those are just calls, right? Those aren't even injuries. That's just when an ambulance goes out. And so, we got some of the AMC employees into deposition under oath. The story starts coming out. And so, of course, we hired an engineer to go check it out. And he says, this is like kind of your garage floor, if you can picture it. It's like your smooth concrete garage floor. And he's like, that's completely inappropriate for a business that's outdoors in the rain. So you got the wrong type of surface. You got plenty of notice, right? The business should know it's a problem. And then the engineer says, guess what? They can just paint epoxy paint on it that has an abrasive paint for 50 cents a square foot, including labor. I'm like, all right, so now we got, now we got a case.
Yeah.
It's a tough case, but I believed in it. And yeah, AMC didn't. So the insurance company for AMC said, we're not paying you anything. It was a zero offer case.
Zero offer case.
Until a week before trial. So it took 2.5 years before AMC even admitted that there might be a problem. And they offered $75,000 a week before trial, at which point, I had spent probably half that in costs for the trial.
Yep.
Already spent it. And my client's medical bills, were more than that. And so that offer of $75,000 was a huge negative number to my client.
And it's such a tough position to be in, right? As an attorney or as a plaintiff, because obviously I read your trial brief on this case, and the plaintiff's injuries were so severe that she had a complete fracture of her hip, right? It was a complete bone in hip fracture.
Yeah.
And I'm not using the correct medical terms on this, obviously, but you almost can't accept that offer. You would be doing your client a disservice to accept that offer when they're going to be putting a couple grand in their pocket at the end of the day, after expenses, after medical bills, after everything else. And the theater knows that, right? The defense knows that, and they try to give you this low ball offer right before trial. So really what these cases often come down to for premises liability cases is it's an all or nothing thing, right? It's either a huge verdict or a zero result if the jury doesn't buy the liability portion of the case.
Yeah, and to be honest, sometimes as a trial lawyer, you're thankful for that because it takes the pressure off of you and your client to make a really tough decision.
Right.
My client, this is just a personal factor. She lived in a trailer park in Spring Valley. Like they had been missionaries their whole lives. They'd actually lived in Japan as missionaries for 20 years. Hadn't paid into Social Security because they were overseas. So just personally, they're broke. They're very low income. So if AMC had come back and said, yeah, we'll give you $200,000 for that case, I think that would have been undervaluing the case. But you have to have a tough conversation with your client about, hey, this will put a check in your pocket that's not an insignificant amount of money.
Right.
But thankfully, they didn't do that. And so, yeah, they forced you to trial. And I recently read Chris Voss's book on negotiations called Never Split the Difference. Mm-hmm. And if you believe in your case, you owe it to your client to go fight for the full value of the case. And so especially if AMC is not even giving you a good compromise. So for me, it was easy. But even if AMC had said, look, you think the case is worth $1.8 million, you're out of your mind. We think the case is worth $75,000. How about we just cut the baby in half and give you $300,000 or something?
Right.
You're like, at some point you have to say, no, I'm going to try the case because I believe in it, and I want to try to get my client full justice, not just some compromise.
Yeah, that's a fantastic point. I often am able to learn so much from interviewing jurors after a case and asking them questions. Were you able to do that at all in this case?
So it's funny you ask that. No, and I'll tell you why. And this is a practice tip because I had heard this from another good trial lawyer, and I had saved this tip. Usually, once the verdict is rendered, the foreperson in the jury stands up, says, Your Honor, the jury has reached a verdict. And then they give the verdict to the clerk. And then the clerk gives it to the judge reviews it, gives it back to the clerk. Then the clerk stands up and reads it. And then after it's read, it's like, okay, we're done. The judge thanks the jury. And then the jury just wants to get the heck out of there.
Right.
They're like, dude, we've been here all week.
Right.
Like we're out of here. But usually the judge will say, now, ladies and gentlemen of the jury, now that your service is complete, you're no longer prohibited from discussing this case with anybody that you want. But you don't have to discuss the case. So if someone tries to pressure you, or if a lawyer wants to, go talk to you, you don't have to talk to them. But I'll tell you, ladies and gentlemen of the jury, the lawyers would very much appreciate your feedback. And if you have questions for them, the lawyers would love to speak with you. So usually the judge will kind of give that pitch, and then the jury will wait outside the courtroom for a few minutes while the lawyers finish up, and then the lawyers go out and speak to the jury. And it's a really cool time because it's like the curtains have been taken down.
Right.
And now they're like, hey, remember on Tuesday when like you said that, but like the witness did this, like, you know, you get to talk.
It's like being behind the glass of a focus group, right?
Yeah,
and you get to ask them the questions
Yeah,
afterwards.
Exactly. But in this case, the judge said, now, ladies and gentlemen, normally I'll let the jury do that, but because it's Friday and it's late, I'm going to order you to leave the courthouse.
No.
And I'm going to ask the lawyers to stay in the courthouse for the next 10 minutes so that you can vacate the courthouse. And I spoke to some seasoned trial attorneys who were like, and this is like a lesson, is like, you just got to do what's in your gut, what you feel is right. You just have to trust your instincts in trial. And what I should have done was I should have popped out of my chair and said, Judge, you know, that's inappropriate. The jury has a right to speak with us if they want to speak with us. Once they walk out of the courtroom, I don't have their cell phone number, their email. I can't reach them.
Right.
You know, so Your Honor, this is my one chance to get some feedback from the jurors, which, by the way, if you're ever thinking about trying to appeal a verdict or overturn a verdict or file a motion for a new trial, you need to get declarations from the jurors if you're going to allege that there was juror misconduct.
Right.
And so because it had been a defense verdict, I wanted to speak to the jury and be like, hey, what happened back there, right? And so I thought it was very inappropriate that the judge did that. And I wish that I had stood up and said something. But I did the next best thing, which was a trick I'd learned from another lawyer, was I had printed out form letters to thank the jurors for their service.
Oh, wow.
And I had an assistant before waiting outside the courtroom. So as the jurors filed out, the assistant gave all the letters.
Oh, smart.
It said, you know, thank you for your service. I'm not going to bug you if you don't want to be bugged, but here's my contact information. You're welcome to call me. So thankfully, 2 or 3 jurors did follow up afterwards.
Oh, wow.
But if I hadn't done that, because of what the judge did, I never would have been able to even talk to the jurors.
So either when those jurors contacted you or just in general, what were some of your biggest takeaways from this case? I mean, obviously there are a number of different ways to answer this question, but you know, what I'm hearing is, you know, as a plaintiff attorney, I'm hearing you have to be so careful with premises liability cases in general because they are so difficult to get past that liability portion, even into the damages portion of the case. So I see that as a big red flag from a business standpoint. What were some of your biggest takeaways from this case? Yeah,
so after the verdict, I was really, really frustrated. Because for me, I truly believed in the case. Yeah. I felt like this is that movie where you've got the evil business, right? And of course, I'm biased, right? So you know, AMC, don't sue me. You're not an evil business. But I did feel like the business could have done better, and they chose not to. It wasn't like a goof, right? Mm-hmm. This was preventable. It was a system failure on behalf of the business. But when I spoke to the jurors, when they called me a few days later, it was really disheartening to me personally because they said, you know, we listened to all the evidence fairly. You know, there's no juror misconduct. You know, we really struggled with this. And it was a 2-day deliberation. And so I started to get excited after 2 days because I thought the way a verdict form works is there's the first question, which says, was the defendant negligent? And then after that are all the other questions about how much money, what are the damages, comparative fault. So I thought, man, 2 days of deliberation, they have to be talking.
Yeah, usually that's great.
They have to be talking money. But when I talked to the jurors, they said, no, we spent the whole 2 days talking about whether or not AMC was negligent. And we agreed with your side that AMC could have done better, but we disagreed that rose to the level of negligence. And it was a split verdict. And so, and I don't know this part, but because it lasted 2 days, I suspect that the deliberations probably started out close to 50-50. And then as the 2 days wore on, it started to shift towards AMC. And then at the end of it, there were still 2 jurors who refused to vote for AMC. There was 2 jurors who said, I believe in my deep heart of hearts that AMC is absolutely negligent. I'm not going to vote for that verdict. So I still had a split verdict after 2 days. And so, yeah, my biggest takeaway was that, so sorry, I just rambled for a long time there, but my biggest takeaway is that as an advocate, you can truly believe that, when there's a problem or an accident that causes an injury, you think that it's not an accident it's negligence. Like someone screwed up and it could have been preventable. But when a jury listens to it from a neutral standpoint, they could disagree with you. And when it comes to premises cases, it's like, this is just an old lady slipping in the rain.
Yeah.
Like, yeah, it happened before other people slip in the rain, But so you really have to be careful as an advocate, not just that there's a problem and not just that someone screwed up that you think is negligent, but whether a neutral person thinks that rises that high level. Because folks are pretty considerate. Like they were very genuine in their deliberations about, hey, we have to be very sensitive if we're going to hold somebody responsible for this loss. Because it wasn't a small loss. I was asking for $1.8 million. And so I think the jury took that very seriously of like, hey, we got to be pretty dang sure before we say that AMC is negligent, even though they agreed with me that they did wrong and they could have done better.
Yeah. And, I'm hearing exactly what you're saying. And it's such a hard thing because we are taught as attorneys not to violate the golden rule and not to get jurors to try to put themselves into the shoes of your client and how they would have acted in that situation. But it's such a natural tendency for people to do that, right? And when people hear a story like your client who slips on a surface, they instinctively, so many times, they instinctively think to themselves, well, would I have slipped there? Like I could have done something different, and I probably wouldn't have slipped there. So maybe she shouldn't have slipped there. And it's what makes those premises liability cases so difficult. But I said in the beginning of the podcast that that you are a local hero for taking on these tough cases, and I truly mean it because I've spoken to so many attorneys who are on the Consumer Attorneys of San Diego listserv, and when one of us, it's like a family, right? When one of us goes and we take our licks, we go to trial, we show the insurance companies that we will go the distance and we will take something to trial, we all benefit from it. Because the next time that we are negotiating with an insurance company, we say, hey, we're willing to go if you guys are, and you have to show them that you're willing to call their bluff every once in a while in order to go the distance and to get the results that you want later in settlement.
Yeah, absolutely. And I will say this, though, about insurance companies. As much resources as they have, they're super cheap. They're like frugal. They're the most frugal. They underpay their lawyers. They overwork their lawyers. They understaff their law firms. And so a lot of plaintiffs' lawyers don't really appreciate that your defense lawyer has 40 other trials coming up. And if you stop for a second and you go, wait a second, of those 40 trials, maybe a certain portion of them are bad cases that shouldn't go to trial. A certain portion of them are excellent cases that the insurance company is going to settle. They're going to pay them because they're great cases. Then you have these gray cases in the middle. People don't stop to think, wait a second, if all 40 cases went to trial, even the bad ones and even the excellent ones, it would sink the insurance.
Right.
It wouldn't sink their bank account.
Right.
They have plenty of money.
Right.
But they wouldn't be able to send enough lawyers to go do those trials.
Right.
And so then it's like this thing where you just have to go to trial. You just have to do it. And so on this AMC case, one of my favorite things about it was I had a friend, Carrie Nahama, shout out to you, Carrie, if you're out there, who called me, and she had the same defense lawyer from the same insurance company law firm that called up the day after my verdict and settled her case with her.
Wow.
And so I can't guarantee that it was my trial, but I know that defense lawyer wasn't working on her case when he was in trial with me. And then next thing you know, he settles her case. And so those are the types of things that as plaintiffs in the bigger picture, you have to push cases to trial.
I'm so glad that you shared that, because that's the exact thing that I'm hoping that we can inspire in our audience. I think when you're in law school, you have this idealized vision for what you're going to accomplish as an attorney and what your career is going to be like. And at some point, sometimes it happens 1 year as an attorney after you graduate if you go work for a defense firm or something like that, or sometimes it happens 10 years down the line, but you can lose that drive. And to hear that you're 10 years into your practice, still loving to try cases, and then you see the result, whether it affected Carrie's case or not, I love to think that it did, because that's exactly why we do it, right? We go to trial and we do these tough trials and tough cases so that we can hopefully get results that are better along down the road.
Yeah, and the tough part too is, going back to the being forced to trial. If the insurance company forces you into a corner, it's hard to get to trial on your best cases, because those are the cases that the insurance company wants to settle.
Right.
And so I feel like, and I can't take any credit for this because all my cases have been very tough cases, right? I'm the guy out there grinding the tough cases, but what I aspire to do is to take the great cases and get excellent verdicts on them.
Right.
So you take the case, and this is what the top trial lawyers across the nation are doing, is they take the case that should settle for $1 million, but they don't take $1 million.
Right.
They go to a jury and say, give us the full amount that you think is fair.
Right.
And the jury gives them $15 million.
Right.
Right. And then that's the top of the mountain. That's where I want to be. That's the trial lawyer, nirvana of saying, hey, I have such courage that I'm gonna, even when the insurance company admits that the case is a good case, and even when the insurance company says, hey, we want to settle, here's our checkbook, what can we write you? Yeah. And you go, you can't write a check big enough to avoid trial. Yeah. Like, we're going to try this case and we're going to get a big number.
It's such a good point. It's always a really good sign when a defense attorney or an insurance rep is like, hey, let's settle this thing, right? Like, what do we need to do to get this thing done? Because that they are very, very nervous for what could happen.
Yeah, but it's tough because, look, there's the realities of business practices, right? If I tried to try every single one of my cases, it would bankrupt my law firm.
Right.
So it's like, all right, like that's, it's a reality. Right. And same thing with clients. When you have a fair compromise, your client's looking at a decent sized amount of money and they say, I don't want to go to trial. Trial's risky.
Right.
Matt, didn't you get defensed in your last case? You're like, yeah. And you could get defensed if I take your case to trial. And then the client says, well, look, you're out of your mind if you think I want to do a trial.
Right.
And I have some clients at the very first day that they sign up with me, they say, I don't want to do a trial. They say, promise me we won't go to trial. I'm like, well, I can't promise that.
Right.
But so you have these different factors of your clients wanting to settle, the insurance company offering a fair amount, the reality of just a business, as from a business perspective of, trials are expensive. But I do think that as plaintiff lawyers, everyone can do better of pushing that line further to trial.
Absolutely. Matt, it sounds like, and you've explained this yourself, that you like this idea of David versus Goliath. Have you always been like that? Where does that come from? Take us back to 10-year-old Matt. Where put us in the right geography. You're in what are you in, like third or fourth grade at that point? What would your third or fourth grade teachers say about you? Are you that kid that's standing up to the bullies on the playground?
Yeah, I was the little spunky kid. I'm not big these days, but I was like the scrawny little kid.
Where'd you grow up?
So my family moved a lot. I was born in New Jersey.
Hey, me too.
Livingston.
Yeah. Wait.
I was born in Livingston.
Me too. Same part of this hospital.
I moved when I was 1 year old.
I thought you looked me up or something. You're like, Livingston. I was like, yeah. That is absolutely hilarious. That's going to be a soundbite.
Yeah. That's so funny. I bet we were born in the same hospital. I don't know what hospital I was born in because my family moved like when I was a little baby. But
yeah. How long were you in Jersey for?
Oh, I think a year or 2 years. I don't remember. But then we moved to.
I knew I liked you.
Yeah,
we got Jersey blood.
The connection. Here we go. And my family moved to suburban Detroit in Michigan, and then we actually lived overseas for 4 years. So my dad was a professor, so we moved around a little bit.
Oh wow.
And so we were in Moscow, Russia for 4 years.
Wow.
Yeah, from 90 to 94. So we actually moved right after the Soviet Union fell.
Wow.
Because the country opened up to outsiders.
Wow.
And but I grew up in the Bay Area here in California, then went to college at UCSD. But no, I was always like the scrawny kid. In fact, in the senior pop polls in high school, I won the Scrawny to Brawny award. And so I know, isn't that funny? The Scrawny to Brawny.
Scrawny to Brawny. I like
Because
that.
I did wrestling and football. And so I had like my team photos of like this like scrawny little freshman. And like, I'm not going to say I was like jacked or anything. I wasn't a supermodel, but I got pretty fit,
Right.
doing wrestling and football. And I had a good picture of me at the end. So
That is so funny.
Yeah. No, I do consider myself kind of the scrappy, go-getter. I'm competitive. Yeah.
When you were in Russia, how old were you while you were there?
So I was there from first grade to fifth grade.
Wow.
So it would have been like 5 to 9.
So cool. What did your dad teach?
Ironically, Christian theology.
Oh, cool.
And in Russia, he taught at the Department of Atheism.
How did that work?
Well, that's what it was, because it was the Soviet colleges.
Right.
They didn't have a theology department.
Right.
They had a Department of Atheism.
So did he teach
communism's
religion to a people that weren't religious, right?
Exactly.
Wow.
And his focus as a professor was Eastern Orthodoxy, because of course that's the church in Russia.
Mm-hmm.
It's the Orthodox Church, right? The church splits.
Yeah.
So yeah, the Eastern Orthodox Church in Russia.
And did your mom work as well?
Yeah, my mom's a school teacher, or was.
Wow.
She actually retired last year.
Oh, congratulations.
To take care of we have a 1-year-old right now. So she
wow.
retired to take care of, and she's our second. She's taking care of the grandkids. So my mom was a school teacher, and she did a little bit of teaching when we were overseas, but mainly took care of the family while we were overseas. But when we moved back to California, she went back to teaching.
Were you a really studious kid in high school and growing up, or were you more of a class clown and you're down in law school, or what?
No, you pegged me. I was not studious. And so, by the way, shout out to like anyone who's worried about their GPA.
Right.
In fact, I'm lucky that I'm just old enough that colleges, they were still very competitive, but they hadn't become hyper competitive.
Yeah.
I mean, my brother was a bookworm. His GPA was way higher than mine. His SAT was way higher than mine. And he didn't get into half the colleges that I got into. So I do feel like part of it is just kind of a shift in admissions. But
your younger brother, I assume.
Yeah.
Right.
Yeah, I'm the oldest. So I have a younger brother who's 3 years younger than me. Then my sister, I have a youngest sister who's 7 years younger than me.
Oh, wow.
And but yeah, no, I was a class clown. I goofed around a lot, got bad grades, somehow struggled into UCSD, and then got bad grades at UCSD, and then aced the LSAT.
Wow.
I got a 169, so I almost got the perfect score on the LSAT, and then that was enough to drag my butt to Santa Clara Law School.
So talk to us a little bit about law school, right? Because obviously our audience is probably 80% of students who are still in law school. Were there any classes in particular that you think really influenced you in your career? Or if not classes, internships, anything like that that you took that if you were to give some advice to some students right now, you would tell them you should definitely take this class?
Yeah, so all the practical skills classes. So like for me, I'm not sure about USD, but we had an external moot court team that did competitions with other law schools.
Yeah.
We had an internal moot court team that did annual competitions within the law school.
Oh, cool.
And then we also had a trial, I forget if it's called trial skills or just, trial team. We had a class called trial team, which was taught by trial lawyers. And I did all 3 of those. So I was just like super involved. And the other thing I tell law students is, obviously you want to be studious and right, because evidence, civil procedure, those things are legit.
Yeah.
I mean, that's how our practice works as lawyers. Like I wish I had studied those harder. So you got to do that. And of course your class rank and job interviews are very important. But I would say this, that if you know that you want to be a trial lawyer, you don't necessarily need to be top of your class. You don't need to be worried about, the on-campus interviews with the top 10, law firms that are coming in, because you're not going to get those anyways. And if you did, you'll be miserable because you want to be a trial lawyer.
Right.
You don't want to be grinding behind a desk for 2,000 billable hours a year.
Right.
If you know that's not you, be studious, study the law. That's why you're here in law school. But do the practical courses. That's my advice. Do the practical.
How about any internships or externships? Did you do anything while you were in law school? Because I know you say you've been practicing for about 10 years or so. I have as well. And I know the way that law students place a priority on internships now. It's so different than when I was in law school. I mean, having an internship in a law school was almost a rarity when I was in law school 10 years ago. And now it's expected. And if you don't have some type of internship or something going on in your third year, it's just a weird thing. It's a rarity. So what type of internships or that sort of thing did you do while you were in law school?
Yeah. So, I mean, you got to get experience, right? Whether it's an internship or just working. I mean, you have to have experience on your resume to get jobs. And so you got to work at law firms. So, but I did a lot of my internships at the public defender's office. My first year of law school, I actually so I was a paralegal before law school. So after college, I didn't know what I was going to do, but I had been working at the UCSD library. So I kind of liked a little bit of like the book stuff, and I thought, I should go work at a law firm. So I became a paralegal. So I did that for a couple years. So I already had some law firms on my resume. So I actually went back to a law firm that I had worked at as a paralegal during my 1L summer. And I just went and, I guess you call it a clerkship, but I just went and worked for them for the summer. And they were a civil firm that did personal injury work. My second summer, I did the official internship or externship with the public defender's office. And then same thing with my third year. So I had been, So your 3L would be after you graduate. The summer of your 3L year, I'm losing track.
Well, so you have 1, 2, and 3L years, and then the summer of your 3L year, you're usually studying for the bar or doing something like that.
Yes, that's what I did. I took off thanks for jogging my memory. I blocked that out.
It's been a long time.
I just blocked that out.
Well, it sounds like you spent a lot of time at the public defender's office, and obviously that was an original thought that you might go into that line of work. Was your decision to switch to the civil side of things something that took place in law school, or was that after law school, after you graduated, that you decided to come to the civil side of the law?
No, it was after law school. So that's another piece of encouragement to your students is I thought I wanted to be a public defender. All my connections, all my networking, I was building up to apply for the post-bar clerkship at the public defender's office. Mm-hmm. And then my family moved. My wife and I moved because she went to grad school. Mm-hmm. So I was just totally out of my hands. And we moved down to LA, which is like the largest county in California. I don't know anybody. I'm like, well, there goes all those connections.
Right.
Like, now I'm in LA. I don't know what I'm doing. And so I just kind of fell into, I have a friend of a friend worked at a personal injury law firm. And so I just took it out of necessity. And I don't know about you, but we graduated shortly after the Great Recession. Mm-hmm. So jobs were tough back then.
Yeah.
And so I kind of found that job and just said, great. So it was out of necessity. But like I said earlier, I really came to appreciate the similarities of you're representing an individual, you're not billing, right? I mean, if you're a public defender, the government's just paying your salary.
Right.
And by the way, the government's paying for the trials too. So you get free trial experience if you're a public defender or a district attorney. And you're representing an individual. And generally, your clients are in a tough spot, and you're helping them out. So, as a lawyer, you're part therapist, part accountant, part doctor. You're like really there to help your client. And so I just kind of fell into it, and I loved it, and I have never done anything different ever since.
So what was that first job that you took out of law school? It sounds like you worked at a personal injury firm. Did you have any sort of mentor that helped you in that first job that really showed you the ropes and taught you about personal injury law? Because obviously, like you said, it's not something that you necessarily get too much practical experience with while you're in law school, right? So did you have a mentor in your life at that point in time?
Yeah, of course. So the lawyer who got me the job, Garrett Fry, he now runs the law firm. He and I were actually about the same age. That's how we knew each other, was we had gone to college together. But he was ahead of me by 3 or 4 years because he hadn't worked. He went straight to law school.
Right.
And so that's how I got the job, was just a personal connection. And he absolutely was like, hey, let's do this. And I think it was kind of more of a, he was happy to have a friend at the law firm.
Right.
But I learned so much from him
Yeah.
in those early years, for sure.
And how long had you worked there before you decided to start your own practice? I mean, what was in between?
2 years.
Mm-hmm.
2 years, I think I was at that firm, Belgium Fry, although now it's Belgium Fry and Van Allen. 2 years, and because that's how long it took my wife to finish her grad school, and she's an epidemiologist. She does clinical research, so biotech.
Yeah. Wow.
So of course for her, there's it's like, what job do you want? Like,
right.
You can pick 10.
Especially right now.
Yeah,
right?
especially right now. Yeah. Yeah. COVID, man. It's her Super Bowl right now. So, but she got a job back in San Diego, which is where we met. It's where we got married because we went to UCSD together. Mm-hmm. And so we said, great, let's go to San Diego. My wife's got the benefits. She's got the stable paycheck. I can hang a shingle. I'm dumb enough to think that I know something after 2 years of practicing.
Right.
And so I hung a shingle, and it worked great. I hung in there for another 2 years on my own practice. Mm-hmm. But coming up on 4 years, and I'm getting ahead of myself, but I had, every lawyer is afraid of not getting clients. If you start your own practice, I'm not going to get clients. And you started your practice, so you know that's totally not true. There's the cases are out there.
Right.
It's just a spectrum of how good they are,
right,
and how valuable they are. And so it's like, hey, no one's just going to drop a diamond on the floor, right? But hey, a penny? Yeah, I probably saw 5 pennies walking to the courthouse this morning, right? A nickel? Yeah, you probably, you get lucky, you find a $20 bill, right? So the cases and clients are out there. People need representation. The problem is funding those cases. Mm-hmm. And so for me, as a young business owner, this was my first time ever having any entrepreneur experience as a person. I quickly got sunk by my case costs, not my office overhead. I kept a really low, small office, cheap, young, lean operation, right? But funding the trial cases just sunk me.
Yeah.
And so thankfully, I found a lawyer who was looking to hire an associate. But I said, hey, you can hire an associate that has his own book of business.
Right.
And so he was excited because, bringing on a bunch of cases. And I think I had 40 files at that point.
Wow.
Which is a lot. If folks don't know, 40 files is a lot for a single plaintiff's lawyer.
Yeah, and 2 years into your business, that's fantastic.
Yeah, and so he brought me on as an associate, but I did a seminar recently with some law students about the business of opening up a personal injury practice, and a lot of students don't realize that plaintiffs' lawyers, even associates, work under a eat what you kill setup.
Right.
You either have a low salary or sometimes even no salary.
Right.
But you're just getting paid on the cases that you complete. And so that was my setup that I wanted. I wanted that setup because I had all my files.
Right.
And I did that at that firm with Steve Bronson.
Oh, wow.
And so he was a great mentor and lawyer to me, taught me a ton. And at his firm, that's where my trial lawyer training went to the next level, not just from Steve Bronson, who, he mentored me and helped me, but Steve Bronson was really a firm believer in getting the best education you can as a trial lawyer. And so maybe a lot of your students don't know that even after law school, there's a whole variety of some of the top trial lawyers who, after a career of being a trial lawyer, what do they care about? They've already made all their money. They've already gotten all their verdicts. They care about their legacy.
Right.
They want to teach.
Yeah.
And so then Gary Spence, for example, has his trial lawyers, although not anymore, but trial lawyer college. I've seen the mixed martial advocacy. There's Trojan Horse. That's another big one. And then on the East Coast, it used to be called the Reptile with Don Keenan and David Ball. And now it's officially called the Keenan Trial Institute. And so there's all these variety, I call them dojos, like martial arts studios, where you have these top-notch trial lawyers who really care a lot about investing and mentoring into younger lawyers. And so Steve Bronson went to the Keenan Trial Institute. And of course, as an associate at the firm, I ended up doing that too. and they have all these different, I mean, it's just like law school. I mean, it's like they have all these different seminars and practical skills courses. A lot of them you would bring a real case. So it wasn't just up in the clouds, and they were small practical skills. So it'd be, okay, this class, it's a 5-day course. Everyone's going to bring a real case, and there's only 8 people there with a top-notch trial lawyer who's teaching you.
That's crazy.
And I did that for, I think I was with the Bronson firm for 3 years, 4 years. And yeah, of course, the problem though of being a trial lawyer is if you're successful and you start to rack up some wins, and then you build up the war chest, and you say, hey, all right, I can do. I don't need to be part of a firm.
Right.
I'm going to do my own firm. So I feel like that's a natural progression for a lot of trial lawyers as they kind of move through their career. And I reached that point, and Steve and I still co-counsel some cases together. And great law firm, great lawyer. But now I've got my own practice.
So I want to take you back a little bit because you've touched on a couple really important things. I think that what I'm seeing from law students now, and it might be it might be the times that we're in, or it might be the types of personalities where students are drawn to law school now that were different a little while ago. But I'm seeing so many students now who actually want to hang their own shingle and start their own law firms right away, right? And I guess the biggest question that I hear from students all the time is, how do you know when it's the right time to start your own law firm? So for you, it sounds like you got 2 years of experience at this plaintiff's personal injury firm. You started your own firm, and were doing well by any stretch of the imagination.
I would,
right?
no. Financially, I wasn't.
Well,
I appreciate your kindness. But.
Well, you certainly were able to get a number of clients.
Sure.
And then you decide to start your own practice again a second time years later. That is obviously doing very well. So how did you know when to start your own firm? And what was different about it the second time? What did you know the second time that gave you that confidence to start your firm? Whereas if you could have gone back to the first time that you started it, you could have told a younger Matt, hey, look, you need to learn a couple more things or have a couple more, cases in the bank or something like that.
Yeah, that's a tough one. How do you know you're ready to go out on your own? I think that's a question. How do you know you're in love, right? Like, I don't know. I can't tell you that. Like, you're in love when you're in love. I would say just, to younger lawyers, be prepared to fail.
Yeah.
I mean, that was the lesson I learned the hard way of, you see these stories sometimes of folks that go out and they're a younger lawyer, they get a case, they take it to trial, and they get $1 million verdict right out the gate, right? And you're like, how the heck did they do it? Like, what in the world?
Right.
So I can't, I would just say be bold and courageous. Like, just try it, right? I mean, what's the worst that's going to happen? You're just going to lose some money for 2 or 3 years, and you can go do something different.
Right.
I mean, really. I mean, if you're truly, you're worried about losing your house or something. I mean, yeah, you gotta, maybe be a little more conservative.
Right. But that mindset, in and of itself, I think, is what it takes. Right. It's that idea that failure is not the worst thing in the world, right? If you actually go and you try to start your own business and it fails, so what, right? Then you go get a job at the end of the day.
Yeah.
But if you have that entrepreneurial side to you, then you have a chance of being successful, hanging your own shingle and starting your own thing, right? There's a lot of factors that are out there that will determine whether or not you're successful. You have to have the skills to go to court and win in court, or to settle cases, to work up cases the right way. But if you don't have the faith in, hey, this might not work out, but that's okay, then it might not be for you.
Yeah. I mean, look, as long as you can bankroll your law firm at least for 6 months, you have the money to go out, right? I mean, get a credit. I mean, you don't even need to apply for a loan, right? I mean, you can put a few months worth of expenses on a credit card. Probably not a good idea, right? but you could do it.
These students know all about debt. Okay?
All right, yeah. Well, so I still have a ton of student loans. So that was like a challenge for me. I was like, gosh, dang it, if I didn't have such student loans, I could have done my own practice much better, right? It's like I'm paying double rent as a lawyer for my office. I got my student loans and I got my office.
Right.
Yeah, no, you're right. You just got to do it. I do feel like from a technical aspect of like, young lawyers might feel like I'm not qualified or I don't know the law. And I'll tell you, as a trial lawyer, the level of lawyering I see in the courtroom from lawyers that have been lawyers for 20 years is abysmal. It's terrible.
Yeah.
And I mean, I'll count myself of like, hey, there's plenty of things that I need to improve on. And so the young lawyer who goes in there gets their rudder guide, which, by the way, you go to the law library for free. You don't need to pay for that.
Right.
That's what I used to do. Just when you have a motion, spend a day at the law library. Use their research for free. Go through the rudder guide. Do what the rudder guide says. I mean, that's a. And by the way, if you don't know what the rudder guide is, it's a secondary source. It's a how-to manual.
Yep.
And so it's not the code. It's not the statutes or the case law. It's just a practical how to do law. I mean, they have them on every subject: bankruptcy, tax, trial, personal injury. Just read the rudder guide. Do what the rudder guide says. And if you're practicing and diligent, even as a young lawyer, like a brand new lawyer, I do think that you'll be qualified.
It's great advice because obviously the way I like to figure out a problem is, number one, go to someone who's already done this before, right? And if you have a mentor, you can go and ask someone who's been there before, what should I do here? But no matter what, don't skip step 2. Go to the Rudder Group guide because that will literally give you a step-by-step analysis of what you need to do and how to do it. So that is fantastic advice.
Yeah, I mean, really, law, like I love board games. I'm sort of a board game geek. When I was a kid, I was a computer game nerd. I don't have enough time for computer games now. I wish I did. Some of the games out there look pretty sweet, but law is just, there's rules. And you got to learn which rules you have to follow. You need to learn which rules you can break. I mean, it's just like any game. And that's what litigation is. There's rules that you have to fight the other side on. And so there's nothing stopping lawyers from learning those rules. You're going to make rookie mistakes of like, oh, I didn't know you could do that, or oh, this and that. But that you got to play the game if you want to learn. And you can do that at a firm, right? You can play the game as an associate. But if you are, if you're courageous, like you said, if you've got that drive, try it on your own, see how it goes.
Yeah. I also heard you mention something, let me take a step back. I think that when we were talking about starting your own firm and setting aside some money, I think it's important to kind of draw the difference between doing what we do as plaintiffs' personal injury attorneys. There's usually a longer payoff, right? So you might get a client and not see a dime on that client's case for a year, 2 years down the road if you aren't able to settle it pre-litigation or something like that. But there are also some things that you can do in order to keep the money coming in and keep the lights on, so to speak. So is there anything that you do in your practice where you have some sort of more of an immediate payoff that pays the rent and keeps the lights on?
Yeah, absolutely. So actually, the one big thing that I have right now that I currently do in my practice is I help other lawyers prepare their clients for their deposition.
Wow.
Right? So, and I'd love to talk about that. But
yeah, please do.
But the two things that any lawyer can do is contract work for other lawyers, and every trial lawyer's association for different areas, right? So you mentioned the Consumer Attorneys of San Diego. That's the Trial Lawyers Association for San Diego. It's like a group of lawyers that are supporting each other, helping each other. If you post on the email listserv for that group, hey, I'm a young lawyer, I'll do contract work for $40 an hour. You'll get inundated by work.
I know, right?
Like inundated, right?
$40 an hour.
If you go, hey, I want to do it for $60 an hour, you'll get a few bites. You say, hey, I want to do it for $100 an hour or $80 an hour. Maybe no one's going to hire you, but the work is there,
right?
And so when you first go on your own, I was doing contract work. I just do appearances, which that's like the lowest level Like, hey, give me $50 and I'll show up at court for you.
Right.
You know, like
even appearances though, it has its place, right? Because I did appearance work when I first started my firm out as well, and I wasn't in it for the $100 that you get when you show up to court or whatever. But you're in court and you're there for a few hours usually, so you're meeting other attorneys, you're getting business cards. It's almost like a free networking event, or a networking event that you're actually getting paid for.
And not just networking, training.
Yeah.
Because the way the docket system works, and again, maybe your students haven't gone and sat in court, which they should if they've never watched. Here in San Diego, most judges have their full law and motion docket on Friday. So go down to the courthouse at 9 o'clock on a Friday. Pick a department and just sit, and you'll hear 50 different matters that have all sorts of different problems. And then you see what the different lawyers say. You'll see good lawyers, you'll see bad lawyers. And it's such a learning experience. So yeah, contract work is number one. Number two, and this answers your prior question of what I did differently the second time when I opened my practice, is plaintiff lawyers love to co-counsel. They love to work on each other's cases. They love to, do legal fee splits. So, hey, help me out on this case here. I'll refer this case to you here. And so when I first went on my practice, I was just trying to pick up cases, and I was like a lone wolf. I was trying to do it myself. Mm-hmm. These days, I don't think I have a single case in my firm right now that is not some way collaborating with some other lawyer.
Wow.
And sometimes it's to get the other lawyer to bankroll the litigation costs.
Right.
They say, hey, you need a trial lawyer? Well, guess what? I need a sugar daddy. So you pay for all the legal costs. I'll try the case.
Right.
It's perfect, right?
That's fun.
Other times it's a mentoring thing. I have a trial coming up right now where it's a lawyer who hasn't tried as many cases. And so they say, hey, I don't need the money, but I'll pay the litigation costs, but come on, let's do this case together.
Right.
And so those types of partnerships defray the risk. It defrays the financial cost of trying cases. And you had mentioned the long-term timeline of cases. I know that's a thing, and everyone, people like to talk about it. But in your cases, sometimes you pick up a file which can be settled in 30 days.
Right.
Sometimes you pick up a Tony Chase versus AMC file that takes 3 years.
Right.
Other times a lawyer refers you a case like the one I'm on right now, where trial's in 2 weeks. So, the timeline, I don't see that as much as a challenge, because I feel like every case has a different timeline. And as a lawyer, you come into the case at a different point on the timeline.
Right.
Every different case.
Right.
So, but it is true that as a business model, personal injury is you're waiting to get paid at the end. So I get that. But going back to the first thing, if I could, on the witness prep.
Yeah, I want to talk to you about that, but I just want to comment quickly, because I think that the co-counseling of cases thing, I don't know if you've practiced anywhere else. I used to practice in New York and New Jersey before I moved to California, and I find that the co-counseling of cases in California is so common, but I never saw it in New Jersey, where I first started my practice, and it was almost frowned upon at my old firms in Jersey. I don't know if I worked at a few firms that were upper echelon PI firms in Jersey, and they were like, oh, we don't co-counsel cases with people who don't work here or something like that. And my father, also, who practiced for 35 years in New Jersey, would tell me the same thing, that it's more of a headache sometimes to co-counsel a case, but I find it so helpful to co-counsel cases for all of the reasons that you've just said. And I wonder if it's a local thing to San Diego, or if it's a California thing, or maybe it's just a sign of the times now, and people are doing it more.
That's interesting. I don't know. And maybe it's just the top firms, right? If you've got a firm that's been around for 80 years or 90 years, and you've got $2 million of operating expenses in your bank account.
Right.
Yeah, you don't need to co-counsel with other people. You can do whatever you want. But no, for us mortals, the rest of us, I think
us lowly plebeians down here.
Oh yeah, no, co-counseling's the best.
It is.
Yeah,
it really
and
is.
you learn. But there are headaches. My paralegal laughs at me when I get a case referred to me from another lawyer, and I look at the file, and I just I start getting a headache of like, this is not organized.
I know.
Where's this depot? Oh, they didn't take that depot. Like
Right.
I had a file somewhat recently where I was like, where's their primary care records? Which, like, if you can imagine from a personal injury standpoint, you're like, your primary care physician has like, that's like the foundation of your health.
Right.
I was like, where are the records?
Right.
Like, they weren't in the file. And so, yeah, there's a headache of like, that's not how I would do things or stuff like that.
But you probably also approach a case from, I call it a unique position, it shouldn't be, but from a trial lawyer's perspective, right? Where that's the way I like to work up a case is, let's assume this is going to trial. How are we going to best prepare ourselves for that end result? Not every lawyer does that, right? So you mentioned this witness prep part of your business. I assume that has a lot to do with the fact that you're always thinking about trial and you are a skilled trial attorney. So what is that exactly? Can you explain that a little bit to our audience?
Yeah, sure. So if your students aren't aware, what most lawyers do to prepare their clients for deposition, and by the way, this is across the board, not just personal injury. I'm talking business litigation, the defense, right? How insurance defense lawyers prepare their defendants for deposition is they'll usually send out a letter, says, hey, your deposition's scheduled for August 23rd. And then, hey, let's have a phone call, maybe a 1 hour meeting, just kind of go over the basics. Some lawyers say, hey, show up an hour early. We'll just, it's really easy. We'll just go over some stuff an hour before the depo.
Right.
And that's it. But I understand why people don't do it, because it's a time suck. I mean, you got to go talk and listen and meet with your client. It just takes time.
So what do you do that's different than what most attorneys do that you just described?
Well, so the first thing is the time. Every single person I prep for either their deposition or for their trial testimony, I always do a 3-day, 3 sessions. Sometimes it's 4, but 3 sessions, 2 or 3 hours a session.
Wow.
And that doesn't even include, as you know, all the regular work of like reviewing the file,
Right.
reviewing the discovery,
Right, of course.
going through. So, I mean, this is like the actual hands-on work. So the time is number one. But then number two, law students will appreciate this, the Socratic method, right? I'm super brutal with my clients with the Socratic method. So the first session, I'll say, hey, before we start the first depo prep session, I want you to write down all your questions, fears, concerns, write them all down. We're going to start there. So then I have them bring that to me. Okay, tell me what your questions are. I'm not going to tell you about the depo. Ask me, and then we'll talk about it.
Wow.
So it has to be client-led. I think that's a big thing. The second session is the actual legal issues that are going to come up in the depo. Because, I mean, you know this, you don't have to prepare with the client of like, okay, so when they ask you, where do you work? What are you going to say? You're like, well, I work at the Clendenin firm, right? It's like, you don't need to work on that. Like, they got that one down.
Right.
But there are difficult issues in every case, whether it's causation issue, like if it's a premises liability case, open and obvious. There's issues that you know are going to come up. But I make the client for the second session come to the second session after doing your homework and think about it. Write down all the problems with your case. Like, what are the important issues that are going to come up in your case? And, your clients are smart. They get it. It's not fancy schmancy legal stuff. This is like common sense.
Right.
You say, well, they're going to say, I should have been more careful. Shouldn't have slipped in the rain. You're like, you got it. Like, now let's break that down. And from the Socratic method, I'll start asking questions. Well, is that true? Like, no, it's not true. Why not? Well, because they used the wrong concrete. It was super slippery. Other people had fallen there, right? Then you're like, oh, now you're getting it. But I led the client there.
Right.
And so now that's become like a core truth for that client. And they'll die on that hill.
Right.
Like, I double dog dare the defense lawyer to try to like get them during the deposition about open and obvious.
Right.
The client will stand their ground. And it's a beautiful thing to see when the client's empowered, they're confident, because they came up with all this stuff. I just kind of was the therapist, kind of asked those questions.
Wow. Where did you come up with that way of witness prep? Because I don't prep my witnesses like that. I like to think I do a good job doing it, but I love that. I mean, that's fantastic. And if this law thing doesn't work out for you, you've got a career as a teacher,
as a consultant,
therapist, whatever. Because I love that you. It's almost like Inception, right? You put the idea in their head and let them just come up with it themselves.
Yeah.
So, did someone teach that to you? Did you learn that as part of your Keenan school of trial attorneys, or where did that come from?
Yeah, so at the Bronson firm, I learned it from Steve Bronson because he is a master of systems. So he was meticulous in this is how we should do this, and not you're never gonna do something sloppy. It's like this is how we do it, and we're gonna be thoughtful about how we do it, and then we're gonna do it that way every time. And so that was sort of my initial approach that I was. That I learned and was drilled into me working at the Bronson firm of don't just willy-nilly. And I do feel like a lot of lawyers, even if they're good lawyers, I mean, like you can get some really top trial lawyers who just kind of ad hoc stuff. And there's a place for that, of kind of letting your spirit free and doing that. But when it comes to something like a deposition, I mean, we do countless depots, right? It happens in every single case. You've got to do it. And so it's like you should have a system for it.
Right.
And so Steve Bronson helped me with the systems of just kind of understanding that. But yeah, at Don Keenan, the Keenan Trial Institute, they have a specific course on witness prep. Drew a lot from that, of course. And then, of course, a lot that I've learned on my own, right? I mean, I don't use the Keenan Trial Institute cookie cutter thing. I've got my own thing that I do. It's, it's just as a lawyer, you're learning from everywhere. But I do think working with Steve Bronson and the Keenan Trial Institute were kind of foundational to having a new respect for systems and taking witness prep seriously.
Yeah.
Because you're going to motivate your client by doing it, by spending the time and doing it correctly. And then you're also building trust with your client. I mean, that's the biggest payoff.
Right.
Is after the deposition, you're like best friends with the client. A lot of lawyers will go all the way up to the depot before they even really start engaging with the client. So you got to take that opportunity at the depot to really connect.
How does that translate if you're doing it for another attorney, right? Because obviously you've said that you've reached a point now and you're skilled enough at this where other attorneys are reaching out to you to say, hey, I need you to prep my witness for this deposition. So how does your relationship that you're building during that dep prep translate to them later defending or taking that deposition themselves?
Sure. Well, I feel like there's two areas that lawyers often will hire me as a consulting lawyer to work on their case just for the purpose of the deposition. It's either a really good law firm that knows they need to spend the time but just doesn't have the time.
Right.
A lot of trial firms will do that where they're like, hey, the trial lawyer is currently in trial on a different case,
right.
But because they do trials constantly,
right?
But we know we need to spend the time, and we want to have someone that knows what they're doing. So that's one where it's like I don't need to teach them anything. They know how to prep their clients for a deposition. They just want me to do it to save them time, and it works great. Lots of times they'll kind of sit in, or I always follow up with the other lawyer so they know what's going on. If there's red flags, I bring it to their attention. Then the other type of lawyer that hires me is a lawyer that wants to learn. Where they're like, hey, I think even if I just hire you once, Matt, I'll get to learn a lot from you,
right.
And you see how you do it. And then those lawyers will often do the prep with me. They want to be there,
right?
And so it's like, great. I love it. You work collaboratively with the referring lawyer, the client, and me. And those I like those probably even better than the ones where I'm on my own because it's more of a team.
Well, you seem like the type of person who enjoys teaching, right? And I find that that's a common trait amongst trial attorneys is because we're always teaching something to someone, right? Our jurors, we're teaching them about the case, and I enjoy teaching myself, right? I do this thing at USD and teach as an adjunct here, but that I think is a fantastic way for some of our young attorneys in the audience to learn how to prepare a witness deposition. That's just, I would think, I don't know what you charge, but it sounds like an amount of knowledge that you get from that you can't put a price on, right? Because that's something that you can take with you for the rest of your career.
Yeah, and that goes back to you were asking how can law students kind of become confident or how can they make the transition to being a trial lawyer? And I mean, you got to go to those education things. You got to learn from other lawyers, co-counsel with a lawyer who does witness prep the right way. When you run into a lawyer that does witness prep, you're like, go work with them, right? When you get a case, bring them on and say, hey, I want to work with you so I can learn your witness prep. Because you're right. Once you learn those skills, you can take that as a lawyer. I mean, there's the other area that in this, like, this is antithetical to me, is like the motion writing. But there's some lawyers that they become geniuses at writing persuasively to the court, at researching, writing, and they do that the same way by learning it, practicing it, and then being mentored by excellent legal brief writers, right, or appellate lawyers. And so you know, I don't have that. I can't go around and say, hey, hire me to help you write your motion. Like that would end terribly. But yeah, you know, it's very foundational that you got to learn those skills.
Yeah. Matt, you had, I mentioned a couple of accolades that you had received in the beginning of the podcast in the introduction. You've obviously received a number of them in the 10 years that you've been an attorney. Is there an accolade that stands out the most to you, that means the most to you, that you've won?
That's a good question. I do have a trophy on my desk, which is for winning the A division of darts for the Greater San Diego.
I love that answer.
The Greater San Diego Darting Association.
That's fantastic. I saw that on your website that you're a dart player.
I'm pretty proud of that one.
How did you get into that?
Law school, actually,
Yeah.
because I'd just be stressed out from classes. I'd never played darts. I mean, maybe like once or twice at a bar, but like I wasn't a dart player. So I just got a board, but like a real legit board with legit darts, not like the little tiny plastic ones.
Right.
And just I get back from law school classes and just throw darts at the board just like therapeutically.
Wow.
And I do that for hours. And so just after a while, and then finally I was like, oh, maybe I should like find some buddies and go play at a league or something. So,
wow.
You know, kind of like a bowling league.
Yeah.
It's a dart league. So
That's
yeah,
really cool.
I'm proud of that one. But I really would hope to get it. I haven't gotten it, but CASD, right? They have their trial lawyer of the year, but then they also have a different one, which I forget what they call it. It's like Street Fighter Award. And basically, you didn't win $1 million verdict, but like you took tough cases to trial.
Cool.
And so the award is not supposed to be like for a result. It's supposed to be for the principle. And so like I haven't won that award, but I know some lawyers that have.
I love that.
And it's super
I feel like you'd be a perfect candidate for that.
Well, I don't know who I need to talk to.
Well, we're putting it out there. Matt, we've obviously spent a lot of time talking about the AMC case, the defense verdict. I now want to turn to some of your more glorious accomplishments, if you will. Okay, so let's ask this two different ways. I mean, there's a lot of attorneys that come on the show and they talk about their biggest verdict. Obviously, you've gotten some large settlements, some large verdicts in your day. What is the case that has meant the most to you? And what is the case that you think is one of the most important cases that you have worked on?
Sure, that's another tough one.
That's what we do here on the show.
Yeah. So the first case I'll mention is my biggest one. Which, and by the way, this is like not a humble brag because you're right. Like other lawyers, like have multi-million-dollar cases.
Yeah.
The largest case I've ever settled was $850.
Yeah.
And so, you know, by personal injury lawyer standards, that's like fairly low.
No, it's a fantastic result. So tell us about it.
So that one was a parking lot, low-speed collision, kind of a fender bender in a parking lot. But it was a gentleman who, you know, he was a construction guy. And he had a bunch of degeneration in his spine because he'd worked a hard life. Mm-hmm. And, you know, this small impact really ruined his spine. And so, of course, the insurance company didn't believe it, right? They said, this is a little minor impact thing. And I worked that case up. That was the first case, one of the first cases that I finished on my own. And, you know, I worked up that case like a dog. I mean, just like 1 million hours on that case.
Right.
And speaking of bad lawyering, the insurance lawyer that was on the other side didn't work on the case at all because he thought the case was terrible. And so all of a sudden, we get to trial. And the other side had messed up all their experts. I got not one, but two of their experts struck by the court.
Wow.
All these mistakes on the defense side. And even though my case was challenging, parking lot, low speed collision, pre-existing,
right.
All these issues, I had the full army out. I had 4 experts, and again, this was a co-counseling case. I could not have afforded to do that without co-counseling with someone who paid for the litigation costs. But I had my voc rehab who said, yeah, this construction guy isn't going to be able to work construction again. And that's whatever, big, so I had, everyone was ready for trial.
Did you use Enrique Vega for that one?
I did.
Right.
I did.
I've got him on a case that I'm working on right now. I've seen him in trial many times, and he's an excellent testifying expert.
Yeah, and Enrique Vega is one of the best when it comes to, which if your students don't know, vocational rehab experts.
Yeah.
They're experts that work at rehabilitating injured people. And so usually it's in the work comp area or just private clinical practice where they get someone who's been hurt. They go, hey, I'm a hairdresser, but I broke my arm and now I can't hold up the blow dryer or whatever.
Right.
Well, it takes a vocational rehabilitationist to either help them rehab or help them look at their career options to say, well, look, you can't be a hairstylist anymore. But guess what? You have the skills to transfer into this other field. Maybe you can be an esthetician because you don't use the hair, whatever it is.
Right.
And so Enrique Vega loves helping people, and he's a clinician. Most of his work is actually helping patients do rehab and choose a vocation that will fit with their physical impairments. So obviously, Enrique looks at your client and looks at their injuries and then makes a determination of how their injuries are going to affect their current career and what their alternate options are that could otherwise provide income, and then says what their loss of earning capacity is.
Yeah. And he's just a great guy, too. You can pick up the phone and get him on the phone very easily. He'll want to hear about your client and how he can help. And so that's fantastic. So it sounds like you positioned your case in a way that obviously led to a fantastic settlement. What was that conversation like? How did you even get to that $850 number just from, did you guys start trial? Was it a pre-trial thing or?
Yeah, so we had done a mediation where it quickly became obvious that the insurance company was desperate to settle.
Right.
And because and again, this is, you got to believe in the cases, right? Where a lot of people would say, oh, you got a spine case, got a surgery, but tough causation. Anything in the 3, 4, 500 range is totally good settlement for that case.
Right.
But because I had worked so hard on the case and because I had realized that the defense hadn't, and then at mediation it became totally obvious that they were desperate to settle, we walked out of the mediation at $600.
Wow.
We said, go pound sand, we'll try this case and go get a monster verdict.
Wow.
And then we went all the way right up to trial call, and then it was either at trial call or the day before, the calls started coming. And again, Chris Voss's book is you just keep asking questions and leaving it open-ended and not giving them any closure. And that drives people crazy of ooh, yeah. So we were at 600, that was your offer. Okay, and you're at 650 now. But what do you think about Enrique Vega? Right? And the other lawyer's why are you talking about Enrique Vega? I want to talk money.
Right.
And you're no, but what about, how do you feel like you're going to handle Enrique Vega?
Right.
Because your expert got struck. Oh, hey, I'm sorry, I got to run.
Wow.
And then it's just then you get a call in 30 minutes hey, it's 750.
And they're just negotiating against themselves.
Yeah, so it's just, it truly does become just a game of chicken of what are you going to pay and what's my reserve? Where do I stop?
And it certainly helps when they know that you're willing to go to trial, right?
Well, not just helps. It wouldn't have been possible.
Right.
You have to be 100% ready for trial.
Right.
And if they had been 100% ready for trial, they probably would have just tried the case after the mediation.
Right.
They would have said, look, $600,000 is a great settlement for this case.
Right.
We're ready for trial, so we'll roll the dice if you want more than 600. but because they hadn't. And so partly I got lucky that it was just positional, and the insurance carrier lawyer was overworked and just didn't pay attention to the file.
Right. Oh my gosh.
But yeah, so we settled for $850, which was excellent, and the client was totally unhappy, like super pissed. It's like one of those things. It's like
The client was unhappy?
unhappy.
No.
Yeah. The client, because we had these discussions of maybe as a again, a lesson learned.
Yeah.
I was so gung ho that I think I was selling him the moon a little bit.
Right.
And then it was like, no, stop, stop. This is actually an amazing settlement.
Right.
We can't risk going to trial. Maybe we'll get more, maybe we won't. But the bird in the hand is too valuable.
Right.
And but yeah, he was super pissed.
It's crazy because sometimes I've learned very early on that you cannot give hypothetical numbers to clients, certainly not to insurance adjusters, but to a client will hear the highest number that you throw out in a hypothetical. An insurance adjuster in a negotiation will only hear the lowest number that you have to say. So
absolutely,
that sounds like a fantastic result based on what I read on that case and the result that you achieved. Whatever the client says about it, it's fantastic.
Yeah,
result.
no, it was. No, that's one where I hold my head up high on that one. That was like a 10 out of 10 win.
Unbelievable.
Yeah, like I still don't know how that happened. Like it just kind of happened.
It's amazing.
Yeah.
Well, obviously, that was a fantastic result. Tell us a little bit about a case that you've maybe wasn't as big of a result, but was a win, right? And that win meant something to you.
Oh, for sure. So maybe, I don't know if you saw on my Instagram, I posted a verdict I got in June this year.
Yeah.
And that was on, again, a very tiny, low-speed neck whiplash case. So, there's a car crash, and the insurance company admitted that it was their fault.
Mm-hmm.
Liability. They say, hey, it's our fault. We admit liability. And they even admitted causation. They said, look, we admit that this crash hurt your client, but she just got a neck sprain. And so my client had gone to urgent care. She had gone to a chiropractor for like 8 sessions, like barely any therapy.
Right.
And then she saw an orthopedic doctor once just to get cleared. And the orthopedic doctor's like, well, you're still having like a shoulder problem. Let's do one shoulder MRI. Came back negative. Her shoulder's fine.
Right.
But like all that medical treatment was about $10,000,
Right.
And so, and of course the law says that the insurance company doesn't just have to pay the economic bills. They have to pay the victim for the non-economic, pain, inconvenience, frustration, just going through it, right? That's like the pain and suffering damages.
Mm-hmm.
So the insurance company has to pay the medical bills plus that. And they just said, this is a minor impact. We'll do you a real solid and give you $1,000.
Wow. That was their offer?
That was their offer, $1,000. Even though, there's $10,000 in medical bills, and they admitted it was their fault. I mean, talk about hypocrisy, right? You're like, when you're a little kid and you break the window with a baseball, like you're taught by your parents to take responsibility. Like you go say sorry, you admit that it's your fault, and then you pay for it.
Yeah.
Right? And so it's just the hypocrisy just drives me insane.
Yeah.
But the insurance companies are really smart. They do that for a reason because they know that no trial lawyer who has half a brain will take that case to trial because it's not worth their time and it's too expensive.
Right.
So fortunately, I only have half a brain. So I took the case to trial and got a verdict of $12,500.
And honestly, I did see that result, and it's fantastic, right? Because it's a similar story to how we started out here. It's like an insurance company daring you and saying, sure, yeah, we admit fault, but we're not going to pay you for the injuries that we've caused. We're going to offer your client $1,000, and we know that you won't try the case, and yet you call them on their bluff and you go out and you get $11,500 over their offer.
Yeah.
Fantastic.
So the day before trial started, again, they increased their offer.
Right.
But it was still a terrible offer. So
and probably too low where you couldn't accept it, where your client wasn't going to come away with it, right? But then you go to trial, you get a verdict.
Yeah. And shoot, I just lost my train of thought.
That's okay, because we're about to turn to a fun portion.
All right, sounds good.
Of the podcast here. I like to ask some fun questions at the end. and sometimes we get some funny answers with this sort of stuff. What is next for you, Matthew Clendenin? What are you most excited about, either in your life, in your career? What's coming up for you in the next couple of months?
Well, I have a daughter who's about to start kindergarten, so I'm super proud as a dad. I love that, and as a business owner, right? I mean, I almost still call myself a solo practitioner because I have a part-time paralegal and a part-time associate, but effectively I'm still a very small operation, and so I have the flexibility of kindergarten lets out at 3:00. Like, first off, I don't know how that works for I have a job.
Right.
I can't stop at 3. But I am gonna be taking, trying to lighten up my schedule a little bit to be with, hang out with my daughter in the afternoon. So I'm stoked on that. I'm stoked that, I don't know about the Delta variant, but I signed up for an Ironman 2 years ago.
Wow.
And I've never done one. Wow. I did a marathon in college. That was a long time ago. But I don't know if you can tell, I'm not an endurance athlete. So this is kind of like a risk for me. But I'm excited for that.
Cool.
And I am excited for my practice that I've been cutting my teeth on these tough cases.
Yep.
But you do the reps, right? You get the reps in. And you're like, that's how you throw a 70-yard touchdown pass. Is you practice the 10-yard out passes 100 times.
Right.
Then your arm gets better. Next thing you know, you're Tom Brady throwing a 70-yard bomb. So I'm looking forward to using the skills that I'm developing to really take it to the next level with larger cases, especially when the insurance company is just denying justice to people. Like, I can't wait to try the next AMC case.
Yeah, well, you're certainly making a name for yourself in doing so, and the attorneys that I work with, the attorneys that I've had on the show, people are starting to know your name now for doing exactly that. So you're doing a fantastic job. Matt, are you a reader?
I am. I'm actually in a book club with all my old college friends. We've been doing a Zoom thing during the pandemic. So yeah.
What books would you recommend for our audience, and what have you read recently that you've liked?
Sure. So I think I already outed myself as a nerd and a board game computer guy. So science fiction, of course, is a favorite of mine.
Oh, I'm gonna write this one down because I'm liking that genre as well.
All right. So, Do Androids Dream of Electric Sheep? And that's a Philip K. Dick novel, which is loosely based off of The Man in the High Castle, which is like a new show.
That's where I know that from, right?
But it's one of those things where the show isn't even close to the book. The book is just different. And the book is amazing. So you should definitely read that book. It's a good one.
Someone has recommended that to me a while ago, and I forgot about it. And I forgot what it was based off of. But I did not enjoy The Man in the High Castle, but I like it.
Don't let it ruin.
Okay, good.
No. I thought The Man in the High Castle was okay, but the Do Androids Dream of Electric Sheep? Oh wait, I'm sorry, I'm totally messing up. It is not based. That's a different Philip K. Dick one. Do Androids Dream of Electric Sheep is Blade Runner.
Blade Runner.
Sorry, everyone's that's like a total failure.
That's okay.
Like I lost
You're
all.
gonna edit all of this stuff out.
Don't out me. No, I'm just joking. You can include it, but no.
Do Androids Dream of Electric Sheep is based off of Blade Runner.
Correct.
Cool.
I totally screwed
Which
that.
I like.
Yeah. The new one and the old one.
Yeah.
And we alternate fiction and nonfiction, so that's fiction. Nonfiction, my wife, who's an epidemiologist in clinical research, recommended a book called On Immunity. And it's not a science book. It's not like, oh, you're an idiot for not liking vaccines. Or it's a really thoughtful book by, I think the author is a journalist. But she just tells a very human story, tracking all different perspectives from the anti-vax movement.
Cool.
Super interesting.
Very cool.
Anybody who is either, super depressed of like, how are there people out there that are anti-vax?
Yeah.
Or if you are anti-vax, you're like, how are there people that are getting this vaccine? The book is great for everybody.
Wow. Very cool. That's awesome. Matt, where can people find you? Are you on Instagram, Facebook? Give yourself a little self-promotion now for your website name, telephone number, whatever information you want to
sure. I'm easy to find. I am not a social media guru. I wish I was. There's some lawyers out there that are so good at it.
Well, I've seen you on there.
Well, I
looked up your Instagram.
I'm trying to put stuff up there.
Yeah.
I think my handle is Clendenin Firm. So CLENDENIN firm. And then my website's just clendeninfirm.com. And my phone number, people are welcome to call me. My cell is 619-432-9685. And my email is just matthew@clendeninfirm.com.
Well, Matt, I want to personally thank you for coming on the show today. We've really enjoyed listening to what you've had to say. And, on behalf of the plaintiffs' attorneys who are practicing in San Diego, getting lowball offers from insurance companies on cases that have real value, we really appreciate what you're doing for all of us. So I'd like to sign off now and say, I am Michael Goldfaden, founder of the plaintiff's personal injury firm, Goldfaden Law, located here in San Diego, California. You've been watching the Barbites podcast with our guest, Matthew Clendenin. Matt, thanks so much for being here.
Yeah, of
Enjoyed
course.
having you.
Thanks.